Good morning, practitioners. I'm waiting for our external speakers to join us so we can start. Let me try to get hold of them. Apologies for that. Okay, I see Stacy joined us. I think we can start. Good morning, colleagues. Good morning, practitioners. Welcome again to another webinar. The topic we're going to discuss today is marital status and sale agreements. We want to understand the legal implications. We know that as marital statuses, they play a crucial role in determining how property is sold, how property is purchased, how property is transferred. We are very happy today to be joined by Ms. Stacey Barnett as she unpacks the legal nuances, responsibilities, and potential pitfalls, that practitioners face and that practitioners should be aware of when facilitating property transactions, especially involved in marital structures. We know community of property, out of community of property, but she's going to take us through all of that. Our main presenter today, her name is Ms. Stacey Barnett. She is the director at Sneyman Incorporated, leading the Bryanston branch and overseeing the firm's marketing and people matters portfolio. She's an admitted attorney since 2008, and she combines her legal expertise with her qualification in life and business coaching to drive meaningful leadership, and she's focused mostly into people initiatives. She's not alone today. She's going to be supported by Ms. Dionalene Pongalani, who is a candidate attorney as well, and she will assist in responding some of your questions that you're going to have today. And maybe let me go through quickly the housekeeping rules before we begin. Your microphones are muted for a reason to allow presentations. Questions may be posted in the chat at any time during the presentation, and we will address those questions during the Q&A segments. You can also put questions on the chat. The presentations and slides and a recorder will be shared with participants after the session. And if you didn't register for the webinar, you can drop your email. We will include you when we share the slides. The recorder will be posted for future references on our YouTube PPRA channel. Tomorrow around 12 p.m., we will post the recorder there. The speakers, they come from external. So I know we might get questions related to PPRA. They might not be able to answer those questions. Can I ask that the questions unrelated to the webinar, we put them on the chat box with your email address, and I will share with the relevant department so they can reply you after the webinar. We encourage you to engage constructively. This is a safe learning space for everyone. Pose your question, raise your hand, we will recognize you. Without further delay, let me welcome our main presenter, Ms. Stacey Barnett, who will take us through today's topic. Ms. Barnett, over to you. Kindly unmute and share your slides. Thank you.
Thank you, Naledi, and good morning to everybody. We are very excited to chat to everybody today and learn a little bit more about one of the most complicated, I would say, determining factors when it comes to entering into an OTP. And I'm going to explain to you now why that is. Just give me a minute so that I can share my screen. Naledi, is Is that good?
Yes, we can see it. You can put it on slide mode. We can see the presentation.
Okay, super. So once again, Naledi, thank you for having us. Thank you for your introduction. Joining me today, as Naledi said, is Dionalyn, who will be assisting me with the training today. As Naledi mentioned, engagement and interaction in our session when it's question time is really encouraged. We definitely find that's the best way for everybody to learn, is listening to other people's experience and learning from that as well. Okay. So today, as I mentioned earlier, marital status, it's one of the biggest stumbling blocks that we see when we as the conveyancers receive an offer to purchase. Sorry, I see there's a question.
We'll take questions after your presentations. We're not going to recognize them now.
Okay. So the topics that we're focusing on today is marital status. Okay, as I mentioned just now, marital status is one of the biggest determining factors and can influence one's capacity to act when entering into an offer to purchase. In South Africa, interestingly enough, we have various different versions of marital status that are either recognized by law, and or if they're not, we need to figure out how we deal with those parties and the way in which they're married in order for us to accurately complete the offer to purchase. So when I talk about capacity to act, there are certain marital status regimes that limit one's capacity to act. And what we see a lot in various offers to purchase is if the agent doesn't understand what those marital status options are, and more importantly, how they may or may not limit somebody's capacity to act, whether it be the seller or the buyer, it's extremely important that the agent is aware of those different options. Because if the offer to purchase is not completed correctly from the word go, I think we all know what the ramifications of that can be. And at the end of the day, of course, as the property professionals in the transaction, it's imperative that you understand at least the basics of what this entails. Okay, so in South Africa, as you'll see on my first slide, marital status is obviously what we're focusing on, and the types of marriages that do exist, okay, and those that are recognized within our legal framework. And then I've also put here a slide around capacity to act when it comes to entities. So depending on how our time goes, I might briefly touch on that. And one of the main reasons why we touch on that is because, again, this is something that comes into play that can affect one's capacity to act when there's a company, a CC, a trust entering into an offer to purchase of sorts. So we'll talk very briefly about that depending on our time. But for the majority of the session, we're going to focus on the marital status and capacity to act. Okay, so in South Africa, we have various different versions, as I mentioned, okay, of matrimonial property regimes, okay? We're going to start with the most simple, and I think everybody's well aware of one that is unmarried, okay? Bearing in mind, this includes parties that are divorced, legally divorced. We will get to the divorce part a little bit later on, but for now, what you need to know in terms of parties that are unmarried, so if a seller or a buyer approaches you and they claim that they are unmarried, technically speaking, it means they have unlimited capacity, which allows them, therefore, to enter into an offer to purchase independently. They do not need any other assistance, okay? Please, this is obviously with the exception of when we're dealing with a minor, okay? Obviously, your minor's marital status will be unmarried, but their capacity to act is not unlimited, okay? And we can talk about that also further down the line. So most common and most well-known, unmarried, okay? The next is we have civil marriages, okay? So with a civil marriage in our country, okay, you can either be married in community of property or you can be married out of community of property with or without the accrual, okay? Again, these can become quite confusing. And let me explain to you why. You guys, as the property practitioners, need to understand what documentation you need to call for in order to clarify the correct civil marriage that exists. A lot of the time, parties are married for many, many years, and they either forget how they were married, whether it's in or out of community of property. They have perhaps lost documentation to prove this marriage, or very simply, they may have not understood at time of marriage what sort of regime they were entering into. So it's critical that you guys, as I say, you guys as the property practitioners, understand what documentation to call for. Okay. So if we focus first on a marriage in community of property, okay, I'm first of all going to explain to you what documents you need to look out for there, and then we're going to talk about capacity to act. So parties married in community of property, the document that you're going to be looking for, and it's the only document they're going to have, is going to be their marriage certificate. So this is the certificate which is issued by Home Affairs, which every person married in community of property should have. Okay, that proves who the parties are that have entered the marriage. It proves the date of marriage. It obviously proves the, or shows, should I say, the marriage officer's details as well. So it's a one-pager document, and you may or may have may or may not have seen one. But that when a party comes to you and they provide you with a marriage certificate and they say, yes, I'm married, I think I'm married out of community of property, and they give you this document and nothing else. They say they have nothing else. They don't give you anything else. That is where your red flag needs to start waving and the alarm bells need to go. Because if it's true that this is the only document they have, okay, and they haven't got an antenuptial contract that exists, it therefore means that they are in fact married in community of property. So just a reminder, in South African law, how it works is if you do not enter into an antenuptial contract, okay, you are automatically and by default married in community of property, okay? Whereas other countries, for example, the UK, it's actually the opposite way around. If you're married, if you do not enter into an antenuptial contract, the default is in fact out of community of property. So why that is extremely important is you will see when one is married in community of property, okay, their capacity to act is completely limited, okay? And the reason being for that is because you share everything with your spouse. You share your loss, you share your profits, okay? I always joke with my agents when I'm training and I explain to them how you need to think of a marriage in community of property is that either party cannot sneeze without the other, okay? And it literally can go as far as that. You need your parties' consent, partners' consent to everything that you do, and particularly when you're entering into any sort of legal contracts, okay? To dispose of property, okay, is important to have your spouse's consent because, again, it's a financial transaction, okay? To purchase property, you need your partner's consent, again, because you are taking on an immovable asset and may or may not be financing that asset. So encumbering the property by way of a bond, again, important and critical that the spouse consents and is party to that agreement. So what I'd like to just highlight here, and again, it's things that seem to come up quite often when we're dealing with transactions, is if, for example, and I'm going to give you practical examples here. Say, for example, John purchases a property, okay? 5 years ago, John purchases a property. 2 years after purchasing that property, John marries Jane, okay? They do not enter into an antenuptial contract. So therefore, they are married in community of property, okay? Now, John comes to you as the agent and expresses his wish to sell this asset. You do a deed search and you only see John's name there. You don't see Jane's name there. Okay. Why is that? Number one, because John purchased the property prior to getting married. Okay. Number two, is John the sole owner of that property? The answer is no. Okay. By virtue of their marriage in community of property, Jane is automatically a 50% owner of that property. And why I want to emphasize that is because when you do your searches, your Lightstones or whatever system you're using, even if you see a copy of the title deed, Jane's name is not going to appear there. So again, going back to what I said earlier, it's absolutely imperative that you ask the right questions, okay? If he says he was married, you don't see the spouse's details there, you need to do some more digging. Because if John on his own enters into this contract without Jane, it's not a valid contract. Okay. So that's extremely important to understand. Okay. Dionlyn, is there anything you'd like to add on in community of property?
No. I think with community of property, again, asking the right questions is what will lead you to the right answers, and make sure that you don't have a little bit of an oopsie daisy later on down the line when you're dealing with your offer to purchase.
Excellent. Okay. Oh, sorry. I'm skipping all sorts of. Give me a second. All right, so we've covered in community of property. Please make notes if there are any questions around this that you'd like to ask at a later stage. And perhaps even any practical situations you find yourself in with this particular property regime. Okay, then another one of the most common matrimonial property regimes that we see is when parties are married out of community of property, with or without the accrual. Okay, so again, parties will come to you and they may advise that they were married and they married out of community of property. The documents you need to call for when this is the situation are two. One, we need to see the marriage certificate, again, the same as married in community of property. But over and above that, okay, we need to see the antenuptial contract. This is imperative as it is proof that this document was entered into between the parties, okay, as in husband and wife or whoever it may be, and it was registered in the deeds office. An antenuptial contract is null and void if it hasn't been registered in the deeds office. Okay, and that's also something critical that we as the conveyancers look for. There are various timelines and signature processes for an antenuptial contract to be valid, and within which time it has to be registered in the deeds office. If that hasn't been met, and the parties think they have signed an antenuptial contract, but in fact their ANC for whatever reason is not correctly registered or signed or notarized, okay, then they automatically default back to married in community of property. Believe it or not, we've had many of these situations, and I'm going to talk to you now briefly about what we would do in an instance like that. Okay. What I first want to highlight, because this often comes up as, again, you know, a complexity which is actually unnecessary to worry about. But whether the parties are married with or without the accrual is actually completely irrelevant to our process in terms of selling or buying your property. Okay. I often find agents asking, you know, how will it affect it, and what happens if they're married with the accrual and these guys are married without the accrual, and you know, how do I cite them in the offer to purchase? That is irrelevant for purposes of an offer to purchase. Whether it is with or without the accrual doesn't mean anything. The accrual is only important in two instances: death or divorce. Okay, because the accrual is going to tell us how the assets need to be split between parties at time of death or divorce. So for purposes of selling or buying an immovable asset, the accrual system is not important. Okay, so all you need to know, don't complicate your lives with understanding with or without accrual. Okay, you just need to know, is there an antenuptial contract and is it properly registered, which you can speak to any conveyancer who will know how to do those relevant checks. I'm not going to explain to you all the detail right now in terms of how to check and what the rules are, because again, that should be the notary's job. And they will be able to do the necessary checks on your behalf if you're concerned. Another thing that often happens as well with an antenuptial contract is parties lose the document. Okay, so they should be in possession of the original antenuptial contract, but often, especially those parties that have been married for many years, have lost the document along the way. Okay, so where we can assist you is ourselves as the conveyancers and notaries. Okay, we can conduct special searches in the deeds office, various deeds offices, so we can check countrywide deeds offices to see if this antenuptial contract was in fact registered in any one of the deeds offices. And when we do those searches, the registration number for that antenuptial contract will pop up. Okay, and then we can actually order a copy of that antenuptial contract as confirmation of their matrimonial property regime. Okay. Again, what the most important part, and I think the point of obviously the webinar, is to talk about capacity to act when one is married out of community of property. Okay. As you will see on the slide, parties married out have full capacity to sign the offer to purchase on their own. Okay. The spouse does not have to form part of that contract. And the same goes with should they be purchasing and applying for a bond, it's absolutely independent. So you do not need consent or co-signatures whatsoever from your spouse. Obviously, it doesn't mean that they cannot be a part of the transaction. Okay, they absolutely can, but should either party wish to independently sell or buy, then this marital status allows that flexibility and freedom, because your estates are completely separate. You're not sharing in each other's profit and loss. Okay, so again, please make notes of questions you might have there. Okay. Foreign marriages. Guys, this is also something that we see. I'm actually going to go back because I don't want you to look at the answer there, but this is something that we see more and more that's coming up. We have a lot of African buyers from North Africa, and again, obviously, that's considered foreign marriage, and we need to deal with that correctly. So before telling you how it works and what the rules are with foreign marriages, okay, I'm going to give you different scenarios. I'm going to take you through those scenarios. I'm not going to give you the answer now, but when we do the question and answer session at the end, I'm hoping somebody will come with the right answer for me. Okay, so first scenario, okay, we've got some nice pictures here for us to easily understand. We have a client, his name is John, okay? John is born and lives in Germany, okay? John decides he wants to go to Spain and run with the bulls, okay? So off he goes, hops on a plane, and heads to Spain, okay? And in between running with the bulls, he meets somebody by the name of Gabriela. Gabriela lives in Spain. Okay. Now, bear those two facts in mind that I've given you. John and Gabriela fall in love and decide they are off to Ibiza to get married. So off they go to Ibiza, have a big party, and get married. Without giving you the answer, I want you guys to think about it and then make a note when I ask you later, what is the answer for scenario number 1? Okay. What country governs John and Gabriela's marriage? I'm then going to move on to scenario number 2. Okay. So Ben is born in South Africa and lives in South Africa. Okay. That next little icon, the flame, for those of you who don't know, like me, is Tinder, right?
Yes,
it's a Tinder. So Ben's lonely. He wants a girlfriend, so he hops onto Tinder, okay? And he immediately matches up with Anya. And Anya, if you didn't know the flag, is from Finland. Okay. So he hooks up with Anya, they start chatting, they're hitting it off. He swipes right, she swipes right, however it works. And they decide they need to now meet each other in person. So they get together, and the chemistry is there, and they fall absolutely head over heels. They can't wait any longer. They want to elope and get married. So, of course, what do? You get on a plane and you head to Las Vegas. Okay. And off they go to Las Vegas and they get married. Okay. Again, I'm going to ask you to think about this and make a note. For scenario number 2, okay, I want you to tell me which country governs Ben and Anya's marriage. Okay, what I want to do very quickly as well is I just want to talk about one's capacity to act when we have determined the foreign marriage that exists. Okay, because I'm not necessarily going to give you all the answers now. We're going to take that to the question and answer portion of the discussion. But what we are going to do is talk about how does foreign marriages affect one's capacity to act. Okay. Again, this is something, as I mentioned, that we're seeing more and more. Okay. But what you guys need to almost see foreign marriages as is with limited capacity to act. Okay. What does that mean? That means that the spouse, okay, has to be a party to the transaction. They have to, what we call, assist the other spouse with the transaction. Okay. So with the sale, okay, again, if the party was married, if the party purchased the property and later on got married, so let's take John, for example. John got married to Gabriela, but he already owned a property. Now John wants to dispose of that asset, okay? Gabriela has to assist with the disposal and the transaction of that property, okay? If it were the other way around and John and Gabriela were purchasing a property, okay, if they were applying for a bond, okay, John and Gabriela have to be a party to the transaction. So either which spouse, whoever is the one that's not the main applicant, would have to assist in that transaction. If they were buying cash, okay, it's a different situation because obviously they are not taking on any debt, Okay. They therefore can act independently. However, bearing in mind when it is time to sell, both parties will have to assist the other when it comes to disposing of that asset. Is there anything you'd like to add there?
No, I think what is just very important, rather, when it comes to foreigners, is to just always have the spouse assist, just to be on the safe side, because you don't want to now have a little bit of leeway for where you now have to go back and get more documentation, or now get the spouse involved, and you are miles ahead in terms of how you're dealing with the actual transaction. So just exercise a little bit of caution and ensure that you have the actual people there, the spouse there.
Sorry. Remember, please make a note of the answers to scenario 1 and 2, and we're going to get back to those a little bit later. Okay, guys, let's reverse back to same-sex marriages. For a while now in South Africa, same-sex marriages are recognized in our country, and it's very simple that parties' capacity to act works exactly the same way. Okay, so if they're married in community of property, the capacity is limited, and if they're married out and there's an antenuptial contract, again, they have flexibility to act independently. A lot of the time I get questions around a same-sex marriage, which could be, what's the word I'm looking for? Which could be tricky when the foreign marriage, the parties who are married via the laws of another country, when they are same-sex marriage, how do we deal with that? Okay, so again, it's something that we're going to come back to when we talk about the scenarios 1 and 2, because it's related. Okay, so I've made a note the same there to chat with you guys around that. Sorry, I think my camera's... Sorry, guys, let me just...
Stacey? I think she will try to reshare again so that we get the full screen. Give her a minute. Dion, are you still there? Stacey, if you are speaking on my side, I cannot hear you, but I can see you are unmuted. I don't know, colleagues, if they can hear you. Okay, you've unshared. She's going to share again. Dionalyn, are you still in the room? Can you hear us? Okay, she will join again. Give her a minute.
Hi all, sorry about that. Stacey just got kicked out, so we'll continue on my side. Please do let me know if you can hear me.
Yes, I can hear you. Can we see the thumbs up if you can hear Dionalyn?
Okay, fantastic. It looks like everyone can hear me. All right. So just to pick back up from where Stacey was mentioning about the same-sex marriages. So of course, we all understand that with same-sex marriages, again, either parties are married in community of property or they're married out of community of property. And the exact same things will apply. If they're married in community of property, of course, you need to see that marriage certificate. If they're married out of community of property, you will need to see the marriage certificate as well as the antenuptial contract if it is readily available. All right. Okay, looks like Stacey's back in. Thank goodness. Then I do not have to talk anymore.
Okay, let's allow her to try to share.
Okay, sorry about that, guys. Can you hear me again? Everyone good? Okay, sorry. Dionlan's going to share the presentation from her computer so that I don't come up with hiccups again. Okay, let's carry on where we are. So just a quick recap. We've had unmarried, we've had married in community, we've had married out of community of property, we have had foreign marriages, we have had same-sex marriages. Okay. Now we are going to move on, and I did warn you guys, there are many different options when it comes to marital property regimes within South Africa. So we must march on. Our next marital status that we are going to be speaking about is religious marriages. Okay, guys, again, religious marriages, it comes up often. And the reason why at the moment it's been a little bit of a gray area, okay, is particularly because of the change in law that's recently happened. Okay, so when we talk of religious marriages in South Africa, we're mainly looking at Muslim marriages, Hindu marriages, Islamic marriages. Okay. Previously, religious marriages were not recognized in our country, okay? However, recently, this has changed. You'll see the case law that's cited at the bottom of that slide there. That was, I think, judgment was handed down beginning of this year, in April this year. So it's very recent. But basically, what it used to be was that if parties were married, if parties are in a religious marriage alone, so no civil marriage as well, just a religious marriage, and they show you their certificate, okay? Previously, because it wasn't recognized, we would cite the parties predominantly as unmarried by virtue of the fact that it wasn't recognized, okay? Which then actually allowed parties to enter into transactions independently because they were viewed to be viewed to be unmarried. Okay, things have now changed, however. Okay, due to this recent case, how it works now is that religious marriages are in fact now recognized. Okay, however, where it is important to note is that they are recognized under the precipice that the marriage officer, okay, that it is that the imam, who is the priest that covers the marriage, okay, that person has to be a registered marriage officer in South Africa. And that's where it's important for us, because if that is the case, they are actually then deemed to be married in community of property, unless, of course, they have an antenuptial contract that was entered into as well. So I hope I'm making sense and I'm not complicating it too much. But what you need to know now, if you come across parties that have entered into a religious marriage, if the imam who has married them is a registered marriage officer, then it is a recognized marriage in this country. Okay, next we are moving on to customary marriages or traditional marriages. Dionalyn is the guru on this topic, so I'm actually going to hand over to Dionalyn to talk us through these options. Again, it can be a little bit complex, so please make notes if you have any particular questions to ask us at a later stage.
Okay, thank you, Stacey. So the only reason why I am the expert is because I was looking at how I could marry the Zulu king so that life can be slightly easier now. All right, so when you're looking at different customary or traditional marriages, what you need to keep in mind is which custom are you dealing with. So in this country, we are blessed to have different and various customs. So each custom will have its own laws in terms of how to recognize a marriage. And the law did look at the same scenario and said, okay, because there's so many various customs that we're dealing with in the country, how do we try to simplify it so that we have almost a standard way of looking at how traditional or customary marriages are handled? And the best way was to look at how marriages begin. And all marriages begin with lobola. So once that process has been initiated, the law has decided to look at it from the date of lobola as these people are now married. Now, how are they married? If they have conducted an antenuptial contract before the date of lobola, then they are married out of community or property. However, if they have not done an antenuptial contract before date of lobola, then they are now married in community or property. Now, I know a lot of people always say, oh, but on date of lobola, no one has finished paying all of the money. And as we all know, there's a very common saying that there is no such thing as finishing paying lobola. You will die and you still owe your wife's family or whoever's family money. So the rule is from date of lobola, regardless of whether the husband to be or whoever it is has only paid 100 rand or even fake monopoly money as we recently saw, they are considered married from that day going forward. So what you must be cautious about, if someone tells you that, oh, I'm married traditionally, ask two questions, okay? Did you do an antenuptial contract? And then also, have you had your lobola date? If they answer yes to the antenuptial contract, then okay, I'm citing them as married out of community of property, so only one party needs to be a part of this. And if they say, no, we actually have not concluded an antenuptial contract, we just had the lobola day, then all right, I'm now viewing them as married in community of property. I need to have both of their signatures on whatever documents that I'm going to be dealing with. And then the marriage that I was trying to get into, polygamous marriages.
Hold on a second. Somebody just commented to say, can you just repeat the last part? Their sound was a bit off.
No worries. Okay, so just to repeat what I just mentioned is that you need to think of two questions in mind. Number one, did they conclude an antenuptial contract before date of their lobola? And number two, have they already had the day of lobola? So if they have an antenuptial contract, then all right, I am citing these parties as married out of community or property. If they have not and they continue to have their lobola day, then you know that these parties are married in community or property and you need both of them to sign on the document. And then back to what I was saying about the polygamous marriages. We are finding that quite a number of people are now opting to go for polygamous marriages. Now, this can be very tricky in terms of how you cite them and, of course, how to verify that the polygamous marriage is actually recognized by the law. It does slightly get complicated, so I'm going to just try to keep it as simple as possible. But essentially, if you're dealing with parties that are in a polygamous marriage, please always let your conveyancers know immediately that, okay, these parties have noted to me or they have informed me that they're actually married according to polygamous marriage in a customary way. The reason why I'm saying this is so that us as the conveyancers can now get the correct documentation that we require from them. So what I would suggest you get from them is, of course, you want to know, did the first wife consent to this marriage? If the first wife has consented to the marriage, then you will have a legally recognized polygamous marriage. If the first wife has not consented or is in fact unaware about this marriage, then rather cite the party. And when I'm talking about parties here, I mean the second wife. If the second wife is the one, of course, who wants to purchase the property, or the third wife, whatever number of wives she may be, if they're the ones who want to purchase the property. If it is the husband and the second wife that want to purchase a property together, please do a letters, because as I mentioned, it does unfortunately get very complicated. So you just want to find out if the first wife is aware and has consented to the marriage. If they are, then you just cite them as married according to customary rights or married according to traditional marriages. And then we will ensure that we obtain the relevant documentation as well as how we will cite them on the actual title deed going forward. But yeah, it can be a very fun one, and I'm looking forward to all the questions that I'll probably receive after this.
Indeed.
Yeah.
Thank you. Okay, guys, something that I forgot to mention, and my apologies for taking a couple of steps back, but with regards to our sort of most common options, which are married out or married in community of property, I think I forgot to explain to you guys how we deal with the situation, or what are the parties' rights when it comes to thinking they are married out of community of property, but in fact they're married in community of property. That can be quite a tricky one because of all the reasons that I've spoken to you guys about. But I think what you need to understand in South African law is an antenuptial contract means prior, means before. So you need to have entered that prior to your date of marriage. Okay. However, if you unknowingly entered into the antenuptial contract and the antenuptial contract is not valid for whatever the reason, okay, as I mentioned, you're automatically, okay, married in community of property. Now, the parties are having an absolute meltdown because of the situation. What are their options? Their first and most simple option is actually to get divorced and remarry. Okay, but for obvious reasons, the parties aren't always keen on that. The second option, which the Marriage Act allows for, is actually to apply to the High Court for what we call a post-nuptial contract. Okay. This is quite a lengthy and costly exercise, okay, because we are now dealing with the High Court. And how it works, I mean, obviously it's a whole application, but one of the main things is that the parties need to actually get consent from various, creditors, allowing them to be able to dissolve the in-community of property marriage and enter into a post-nuptial contract. So it's really not ideal. And it has quite far-reaching ramifications for the parties. But those are really your two most important or most simple options that exist if your client, should I say, are stuck in this position. Okay. Some of the so let's just recap very quickly, okay, on our marital status options. We have unmarried, okay, and we have divorced, which I said to you I am going to come back to now. So we have the married in, okay, capacity is limited. We have married out, you have capacity to act independently. Okay. Then we have our foreign marriages, which also we're going to come back to now with our scenarios. I hope the wheels are turning in your head and you've got various answers for me on that. Then we have our same-sex marriages. Remember, it's recognized in South Africa and your capacity is exactly the same as it would be for married in or out of community of property. We then have our religious marriages. Remember, the law has changed quite recently on that, and basically just to say that sorry, if the imam that has married the parties is a registered marriage officer, then in fact it is recognized in South Africa. Then we have our customary and traditional marriages, which, as Deolin has spoken you guys through, there are various different options, but with the Customary Marriages Act that came in 2000, again, it's recognized in South Africa, but there are certain nuances to it depending on the custom and, you know, the rituals, etc., etc. Okay. And of course, the polygamous marriages is slightly different as well, but still recognized. Okay, so that, in short, is a very simple summary of all the different options that you guys, as I mentioned in the beginning, need to understand and need to have basic knowledge of, because that is the starting point of your transaction. And the conveyancers aren't often at that juncture with you in the transaction. You guys are there, and therefore you need to know the basics. Of course, you can reach out to your conveyancer, aka Sneemans. You're welcome to reach out at any time, but it's imperative that you understand the basics and what parties can or cannot do with that contract. Okay. With regards to the unmarried version, I just wanted to mention as well, if parties come to you, and we've seen this, believe it or not, many a time, if parties come to you and advise you that they are divorced, okay, whether they're buying or they're selling, we have to very importantly ask for the divorce decree as well as the settlement agreement. This is extremely important. A lot of people have separated and perhaps been separated for many years, and in their minds, they're divorced. But legally, they're not yet divorced, which again could impact the offer, okay, depending on their marital status and their capacities to act. So it's very important that you guys have sight of that. We as the conveyancers will obviously call for that, because the settlement agreement as well, other than proving the party's legal divorce, the settlement agreement will definitely stipulate what happens with that asset should they have owned that asset together and they're now selling. Okay, so we have to now follow that. It's an order of court. So that's something with regards to the divorce scenario that you may come across. So just please remember to ask for that.
Yeah. I think while you're at that as well, Stacey, perhaps we should mention on people that have been widowed as well, and how that may affect one's capacity to act. So, of course, if you're dealing with someone who unfortunately has been widowed, you just need to make sure, especially if they are the seller, always, please ask them if they have started winding up the deceased party's estate. Because, of course, this is going to affect your transaction. It will affect how fast you guys get paid your commission, as well as, of course, it will affect how the transaction is also going to be structured. And always please keep in mind, when you're dealing with deceased estates, sadly, they do take very long. Depending on how complicated the deceased person's estate is, it can unfortunately take anything between 6 months and upwards. So always also try to manage your client's expectations realistically, especially if you're dealing with buyers, in terms of exactly what the process is. Try get an understanding if they have started winding up this estate. Because if that has not yet even occurred, then you, of course, will know that, well, this thing is going to take much longer than anticipated. Or if they have started at least winding up the estate, try find out from the executor or the administrator exactly whereabouts they are within the process. And that will allow for you to be able, again, to manage realistic timelines with your clients, and of course facilitate this transaction in a much more knowledgeable footing. So things to watch out for when you are taking down the mandate is, especially if it is a recently deceased estate or however long the estate has been deceased for, you just want to find out if there are letters of executorship that have been issued out. Once you have that found out, then at least you know, okay, I'm now going to be dealing with the executor who's going to be representing this deceased person's estate. And then you know at least how to cite the parties as well in your offer to purchase and how to go about with it. And again, more importantly, that you actually do have adequate permission to be selling off this asset.
Thank you. Very important, guys. I think when it comes to deceased estates and estate lates and those sort of things, we can do a whole separate session on that because, again, it's quite a complex topic with various different options. Just something that I want to touch on before we finalize on the same-sex marriages, the foreign marriages. A couple of other things you need to bear in mind while we're speaking of capacity to act, okay? Other than, of course, when we deal with a juristic entity, okay? As I mentioned, which is your CCs, your companies, your trusts, etc. Other than those, there are various other factors that may limit someone's capacity to act. So I briefly spoke about age earlier on, okay? And that's something that could limit one's capacity to act, okay? There are various different age groups that, age groups where you have different levels of capacity to act. So it runs from 7 to no, I think it's, I'll double check on that for you guys. I've just lost the number in my head right now. But the younger age group, you cannot act at all. Your legal guardian needs to act on your behalf. And then the next age group up until when you're a major, okay, which is 18 years old, needs to be assisted by their parental guardian. So there are various different things there that's important for you guys to understand and know. Insolvency is a big one, okay? Important again for you guys to understand that if a party is insolvent and they have disclosed that information to you, then the trustee of the insolvent estate, whoever that is that's been appointed, will actually be the right person to have capacity to act on behalf of the insolvent party. Okay. And another one, which we have come across, although not very often, is when somebody is not of sound mind. Okay. If somebody is not of sound mind, okay, they cannot act in terms of a contractual agreement whatsoever. So a curator will have to be appointed by the High Court to act on behalf of that person. And I think where some people get confused is that it's extremely important to know the difference between somebody that's not of sound mind having given someone power of attorney opposed to somebody who's not of sound mind where a curator has to be appointed. Okay. Remember, that power of attorney is not to authorize somebody to act on your behalf should you not be of sound mind. Okay. That power of attorney is authorization if you physically cannot be there to sign documents and so on and so forth. The curator is there, okay, to act in your shoes and to make the decisions that you as an individual are no longer able to make. And I hope that makes sense to everybody. Just one thing quickly on the entities when it comes to capacity to act, okay? I think it would by now be very familiar for most of you that have, been agents for a decent amount of time, is that if you are dealing with entities whatsoever, okay, it's imperative that you call for the resolution, okay, where one person has been authorized by the other members, by the other directors, by the other trustees, okay. That is imperative, and that resolution needs to be dated prior to signature of that OTP. Okay, that document is extremely important. Another thing that I want to just chat briefly about is something that we deal with quite often in a transaction is when we call for a special power of attorney, where the client asks for a special power of attorney. This is a very limited document where it basically provides authority to an individual for purposes only of this transfer, nothing else. It's an original document that we actually have to lodge in the deeds office, and it's got quite a specific layout, if you like, or template that it must follow in order for the deeds office to accept that. So if, for example, you know that your seller, just say as a practical example, comes to you, even signs the OTP with you, but they're going overseas for a couple of months, just pretend, okay? It would be, again, alarm bells for you guys to contact your conveyancers and say, please, can you draft a special power of attorney so they can authorize whoever they choose to sign all transfer documents, etc., in respect of this transfer, so it's not to delay the deal further than it needs to, okay? Again, I'm not going to go into all the detail now around it's the Rule 63 of the High Court, where documents are being signed for use in South Africa outside. So they're being signed in another country for us to utilize here. There are various different rules, etc., that pop up that need to be followed in order for that to happen. And hence why I mentioned the special power of attorney. Because if you can get there ahead of time prior to your seller, for example, leaving the country, SPA, that special power of attorney to be signed prior to them leaving, it actually saves a lot of hassle because the rules for signing certain legal documentation outside of the country are quite cumbersome and expensive as well. Just as a very small example, we had a client who lived in Australia, but it wasn't a big city. It was in the middle of nowhere. I can't remember exactly where it was. For them to get to the consulate or before a notary to sign those documents would have cost them more money than them flying back to South Africa to sign those documents. So that's exactly what they did. They flew back to South Africa, signed the documents, and then went back to where they came from. So just another reason as to why we need to just be ahead of the game. And the only way that you can be ahead of the game is if you understand, okay, you understand the basic rules and regulations. Okay. And Naledi, I think we finished majority of the content. Would it be okay for us to move on to answering the scenarios and then into questions and answers?
Yes, we can do that. Can I ask speakers, if you are breaking, maybe switch off the video now and then so that other members can hear you, but we can go to the scenario. Yes.
Okay, great. Let's turn off our videos now. Okay, guys, so just to recap, scenario number 1. Okay, we've got John from Germany. He goes to Spain. He meets Gabriela. They fall in love and they head off to Ibiza and get married. Please, can somebody tell me what country governs the laws, okay, of their marriage and why?
Let me unmute everyone. They've unmuted. Rina, you are the first hand. Do you want to try to answer? Okay, let's go to Danny. Can you hear us? I gave you access to unmute. You just unmute and give us an answer.
Hi, Germany, because that's the husband's domicilium.
Excellent, 100%. Who just answered that?
Deborah from Tyson
Deborah.
Properties.
Oh, thank you. Thanks, Debs. Okay, excellent. That's 100% correct. So remember, the laws of the country that will govern the marriage, okay, is where the husband is domiciled at time of marriage. Very important. In this case, John was domiciled in Germany. So yes, he went for a visit to Spain and did all sorts of lucky things there, but it still remains his domicile. Parties had to come to you. They're not going to be married according to the laws of Spain. They are going to be married according to the laws of Germany, because that is where John was domiciled at time of marriage. Okay.
Yes, and I see other practitioners also got it correctly on the chart. Colleen also said Germany. Ralph Menzi got it incorrectly, said Spain, because Ibiza is part of Spain. But that was interesting. Do we want to move to the second scenario?
Yep, let's do that. Okay, so another quick recap. This is where Tinder comes in. Ben from South Africa swiped right, and he met Anya, and they headed, or Anya from Finland, and they headed off to Vegas to get married. Again, I'm going to ask you the same thing. Which country governs the laws of their marriage? Danica. Okay, that's the first answer I see that's popped up. A lot of people are saying the same thing. South Africa. Okay, so they would be governed by the laws of South Africa, and therefore, depending on what they did or didn't do, but if I look at this scenario and they ran away to Vegas very quickly, I'm just going to assume that they didn't enter into an antenuptial contract, and therefore they would be governed by the laws of South Africa, married in community of property. Okay, I saw somebody pop up a question in the chat box earlier saying, why the husband? I don't have an answer to that. That's just how the law is. But where it's an interesting question to come in is, what happens in the instance where it's a same-sex foreign marriage? Okay, there are either two husbands or there are no husbands. How would we determine, or whose domicilium would we determine?
Let's see
Okay,
if they
so
can attempt.
someone has said, let me just scroll down quickly. Someone has
Because
said,
Mbali also commented that scenario one, what if the parties are in the same-sex marriage?
aha,
Um,
okay, excellent. So Danica has answered the question for us again. Danica, they can choose which party's domicilium they take, and that is 100% correct. It's not often we find situations where the parties are not domiciled in the same country, but in the event that they are, the parties are able to elect which domicilium they choose. Okay.
Val says where the marriage is executed, I think is speaking to scenario two.
Right. Okay, Val. So we've figured out it's actually not where the marriage physically takes place. Okay. Right,
Okay.
guys. We are finished with the actual content for now, and I think we can at this point, if you're happy for us to stop sharing, we can take questions and answers for our remaining time.
Yes. I have Anne-Marie on the chat. She says, please clarify at which age someone can purchase a property without the assistance or consent of a guardian or parent.
Okay, so if you're again going to act independently without any assistance whatsoever, then you have to be a major. You have to be of age, which in South Africa is 18 years old.
Okay, thank you for that. Lucinda says, can foreign buyers' marital status be verified by transferring attorneys, even though they have passports?
It's so if the parties do not own existing property in South Africa, it's extremely difficult, if not impossible, to actually verify and prove the party's foreign marriage. So the only thing that you're working on is the information that the parties have given you, and of course the marriage certificate. And we have seen instances in the past where people have been married via the laws of another country, but because there's no record of it in South Africa, you know, it's difficult to prove, and therefore the parties can get away with, you know, citing themselves as unmarried, which is obviously not legally correct.
Okay, thank you for that. I have a career. How do Hindu marriages work?
Okay. So going back to, and sorry guys, I forgot to mention this in the beginning, but we've got a nice summary of the discussion that we've had today. We like to call it the marital status cheat sheet, or the capacity to act cheat sheet, where we've summarized everything we've said, and we will send that to Naledi for her to distribute to everybody. But going back to the question, a Hindu marriage will fall under what we call a religious marriage, okay? And remember, religious marriages are, in certain instances, now recognized in our country. So what that means is, or under what circumstances that will be, is basically where the imam or the priest that marries the parties needs to be a registered marriage officer, in which case it would be a recognized marriage between the parties, and they would either then be considered to be married in community or out of community or property.
Okay, thank you for that. I'm going to go to the hands because I can see we have Rina. Let's allow you to unmute and ask your question. Rina? Okay, I'm going to go to Danny. We will come back to Rina. Maybe she has issues with the network connectivity. Let's go to Danny. Please ask your question. Okay, Danny is struggling. Let's go to Elritha. Elritha, please unmute. Or maybe they can't hear me. Let's go to Renee. Okay, if you don't unmute, I'm going to move to the next person. Let's go to Ansi. Please unmute. Ansi? Okay, let's try Charmaine. Charmaine, before I go back to the chat and we address those questions.
Good morning,
Charmaine?
everyone. Good morning, Stacey. Can you hear me?
I can. Morning.
Okay. Sorry if you did answer my question in the chat. I was thrown out due to my Wi-Fi, so I'm not sure. But with the customary marriage, what FICA documents are applicable for that type of marriage? Is there a registered marriage certificate in that case, or is it just more a case of you need to ask your questions and do like a survey with them?
Good question. Dionelin, you want to take this one?
So with customary marriages, it depends on the parties. Some parties on the day of lobola, they will have a letter that they conclude at the end of the ceremony, which then acknowledges that they are now both married from that date forward. But other people don't do those kind of formalities, and neither do they even register with the Home Affairs. So with those clients, essentially you'll be asking them, so when did you guys conclude your marriage? And then you just take it as from that date of marriage, they are now married in community of property if they have not concluded an antenuptial contract before. So
Okay,
you'll just
thank
be
you.
needing the normal ID and proof of address.
Thank you so much.
Excellent.
Thank you. Let's go to Val. Val?
Hi, how are you?
Fine.
I just wanted to share an information in a case that I heard about foreign life partnerships. They are not by the deeds office considered as marriages, although this couple was told in their country of domicilium that they are married. They have to always state they are married. But foreign life partnerships are considered unmarried in South Africa.
Okay, thank you for the comment. I'm going to take 1 minute break and allow our speakers to drink some water. I want to play a video coming from Sneyman Incorporated so that we can see when you have to go and lodge, when it comes to property, what is the lodgement process that they assist with. Please just hold on.
Phase 5 of the Sneyman's journey, where we have broken down the transfer process into 6 different phases. The next phase, known as lodgement, is where everything falls into place in your property journey with Sneyman's Inc. We've come a long way and it's exciting to guide you through this crucial phase. The lodgement phase is when we as your transferring attorneys submit your documents to the deeds office for examination. This is the final phase of your journey with us and we can't wait to take you through it. The deeds office typically takes between 7 to 14 business days for registration, but please note that this is a general guideline. The exact timing depends on the deeds office capacity and any potential closures. Once your documents are lodged, they go through 3 levels of examination at the deeds office to ensure everything is in perfect order. The next stage is prep, which is an exciting milestone. It signifies that your documents have passed the examination and we're ready for registration, and we are almost there. And once all the attorneys have given the green light to the registrar, the matter goes into execution and the transfer of ownership occurs from the seller to the buyer. For both sellers and buyers, it's time to prepare your move. The property transfer registration can typically be estimated to take place within 7 to 14 days, depending on the deeds office capacity. In the coming weeks, keep an eye for an email notifying you that the matter is on prep. When you receive this prep notification, you'll know that your matter will be registered within the next 2 to 5 working days. We're here to support you every step of the way. You've come so far and we are almost at the finish line. Stay tuned for the final phase, phase 6, where your property journey reaches its conclusion. If you have any questions or need any assistance, please do not hesitate to reach out, because your property journey with Sneyman's Inc. is our top priority.
Okay, thank you, colleagues. I want to say we know that PPRA, they're always informing conveyancers to use a property practitioner that has a fidelity fund certificate. One of our speakers, Daylin Kambule, submitted an apology. She was going to come and give a talk on contracts, offer to purchases, and lease agreements. And I know in her department, they've collected commission that was due to property practitioners who didn't have FFC, and that money was collected by PPRA. And we are going to still have that webinar, I think, once she has recovered, so that we can engage on that, because I know it's some of the issues that affect yourselves as practitioners, especially trying to, earn a commission in your careers. Let me go back to the questions, Stacy. Let me see if I have another question so that we don't disadvantage anyone. Can I please share an information? Okay, this one, Ralph has already spoken about it. Tapelo says, if a parent is purchasing property for his children, I think you want to say 5 children, of which 4 of them are over 18, is it necessary for the one which is underage to have a guardian to sign on her behalf?
Yes, absolutely. Thank you. That's a great question. But anybody who is not of 18 years old, or of age, as we say, will need to be assisted by a parent or legal guardian. We often find, especially for parties where they're purchasing the property for the children's benefit later on, they will often purchase the property in the name of a trust, which will then at a later stage deal with the asset and the children once they have reached, a certain age, whether it be 18 or whatever it may be later on in life. Naledi, would you mind if I just quickly address the comment that came from Val, just quickly before we move on? Val's comment about a life partnership not being recognized. I'm not sure if there was a question there or what, but just to make it clear so as not to confuse anybody, is that there's a very big difference between life partnership and then an actual marriage. Okay, so it needs to be a registered marriage, which then we will determine if it's a registered marriage, just irrelevant in which country, but once it's a registered marriage, that we will then determine how we deal with that and what capacity means. But in terms of partnerships, we don't deal with partnerships. There used to be common law wives, common law husbands. That isn't recognized in our country. Okay, just for clarity.
Thank you for addressing that comment. It was from Ralph, as Val indicates on the chat. I have another question coming from Korea. What if client is selling, I beg your pardon, what if client is the seller and provides a foreign marriage certificate in another language? How do we deal with this? Do we need to translate it and then get it notarized?
Thank you for the question. Yes, we absolutely do need to get that translated, okay, in order for us to obviously see exactly what it stipulates, and in order for us as the conveyancer specifically, but yourselves as well, because we all obligated in terms of FIC. We need to see what the contents of that certificate divulge. It isn't necessary to be notarized.
Just to add to what Stacey is saying, we actually have a scenario exactly like that in the office currently, where we have a couple from the Congo and their marriage certificate is in French. So we only had to have it translated into English, and then we just require, of course, just formalized copies of qualifications of the translator to confirm that this person is, of course, legally allowed to translate this material, and then just their ID. So that is essentially all that we require. It does not need to be notarized, as Stacey has said.
Okay, thank you, Jenalyn, for that. I have another question from Nofundo. How would domicilium work with same-sex marriages?
Okay, so just to go back to what we said, same-sex marriages, if we're looking for domicilium, the parties can elect which domicilium they choose. So it's really as simple as that.
Okay, thank you for that. Let me go. I think there's another question on the chat. Menzi says, what does it mean to be notarized?
Okay, that's a good question, Menzi. So first, let's understand there are different qualifications. So as an attorney, you write certain exams and you get admitted and you become an attorney. If you're wishing to specialize, for example, become a conveyancer, there are other sets of exams and so forth that you would need to do and to pass in order to become admitted again as a conveyancer. A notary is exactly the same thing. You would need to specialize to do your specific exams. And once again, once you've passed that, you get admitted to the High Court as a notary public. There are very specific things that only a notary can do. A notary is deemed to be seen as the highest form of, let's call it authentication, okay, that one can receive. So, for example, you'll get an ID document certified, but then you'll get an ID document notarized. So, depending on what is required, there are only certain things that will be acceptable for a notary to do. For example, there's an antenuptial contract, which only a notary can sign. There obviously notarization of certain documents, as well as any sort of notarial deed in the deeds office. Now, this can vary from, servitudes to sessions, etc., but those are notarial documents that can only be signed by a notary. I hope that answers your question.
Thank you for that. I have Zimasa If an entity owned by a person who is married out of community of property purchases a property but did not sign any antenuptial contract, what happens?
Great question. And that would then take us back to if they didn't sign an antenuptial contract or the ANC is invalid for whatever reason, that party would be deemed to be married in community of property, which means when you are collecting all the FICA documentation, okay, the spouse also needs to be a part of that transaction and FICA'd together with the director.
Okay, thank you for that. Elise on the chart says, if the same sex is cohabiting, for example, 16 years and not married, what then?
Okay, then it goes back to what I mentioned earlier. If the parties are just cohabiting, it doesn't, and for any period of time, it does not deem them to be in a marriage. They need to actually enter into a marriage and they need to have that marriage registered in terms of Home Affairs or whatever the rules are of their specific country. But no amount of time can automatically deem a couple to be married.
Okay, interesting. Menzi says, how do you know if the priest is registered in South Africa?
Okay, so yeah, by the marriage certificate, of course, that will stipulate that as well as Home Affairs.
Okay. And Charmaine says, with a customary marriage, what FICA is regarding the marriage? Is there a marriage certificate maybe required, she wanted to say?
So again, it depends with the couple. Some couples will have a formal letter to formalize that they were married on certain date. Other couples may not have that. So we just take from date of lobola as the date of marriage.
Okay, thank you. And I think it answers another question from Zimasa, where you're saying what evidence would be required in customary marriages. Maybe Dionalyn, you want to just add on that, but looks like you've answered.
Yes, so also just as another thing that we do as the conveyances is that when the clients are signing their transfer documents, they will sign an affidavit in which they are confirming that they did indeed enter into a customary marriage, and then they will put in the date of lobola. So if people are worried about what kind of proof do we utilize, so the affidavit again is commissioned before one of our attorneys or of course by the conveyancer themselves. So that is again another proof to formalize their marriage if they do not have that formal letter.
Thank you. And Trudy, I think your question was also answered because you're also asking which proof does the first wife must give to show consent. And I think the affidavit that Dionalyn is touching on will also cover that as part of the documents. We have the hands. Maybe let's go back to Sindiswa. You can unmute yourself and ask your question.
Hi guys. I just heard, I think Stacy mentioned something that's actually very interesting. So does that then mean if you have been in a partnership, quote unquote, cohabiting with a person for maybe 5 years and longer, and then maybe the husband or let's say the boyfriend in this case, because it's a partnership, passes away, and maybe you have children, how does the law then recognize that? Do you find such cases if ever? Because I know there are people that have partnerships, lifelong partners. So I'm wondering, how does that work in terms of that kind of situation? And is it something that is common? And then, sorry, my second part. Okay, then my second part is, am I correct in saying that in essence, unless stated otherwise, through an antenuptial contract, the law just deems it as in community?
Okay.
Thank
Cindy
you.
Swat, thank you very much for your questions. I'm going to start with your second question first because it's a quick and easy answer. In South Africa, if you have not entered into an antenuptial contract, okay, you are by default deemed to be married in community of property. Okay. To answer your second question, okay, if there is a life partnership, as you spoke of, and their kids and their assets and whatever it may be, okay, first things first is if they haven't entered into a legal marriage, they are not deemed to be married, okay. Secondly, what's extremely important for those parties to do to enable them to deal with those assets and even the children and any sort of inheritance is to enter into a will, okay? Because remember, the will is the document that's going to stipulate what assets get distributed where and to whom and at what stage, etc., etc. If they have not entered into a will, okay, they will be deemed to be married. They will deemed to have died intestate, which means there isn't a will in place. And what happens with intestate succession is where your heirs are determined by your relatives and your blood relatives. Okay, we call it per stirpes, which is a Latin term where basically if you look at your sort of family tree, it will go first to whomever your spouse is. But in this case, if you're not married, it would then go to your children as your heirs and so on and so forth. So it sort of works down the family tree like that. So in order to avoid that situation, and overall just for a much smoother process for the people that are left behind, it's absolutely critical that people enter into a will, okay? Because that will determines everything. And bearing in mind, even if you are married, you need to have that will to stipulate, you know, the disbursement of your assets and so on and so forth. I mean, as most of you probably know, you can even determine a portion of your will as a living will, which talks about how you wish to be treated, if you like, if you're not in a position to talk or make decisions. Say, for example, you've been in a horrible accident, you can stipulate in your will that they must turn off the machines or whatever the case may be. Sorry, it's a very morbid topic, but it is critical that we do discuss it and that people are aware of that. But just back to the property side of things, Cindy, I think if you do own property, whether you're married or not, it's really important that you do have that will.
Cindy, so are you fine? Okay.
I'm fine. Thank you so much, Stacey.
Pleasure.
Okay. So when we share the slides, the contact details of Stacey and Dionalyn will be there if you want to be in touch with them after the session. I have another question coming from Anne Marie. In the case of a couple married in community of property decides to enter into an antenuptial contract after the fact, does their marital status change automatically, or what do they need to do?
Okay, Anna Marie, thank you for the question. I just want to touch on what I said earlier in terms of antenuptial contract. Okay, ante means before or prior. Postnuptial means after the fact. Okay, so if you haven't entered into an antenuptial contract, which is what's recognized in South African law, you then default to married in community of property. Okay, should you wish to change your matrimonial property regime after having been married in community of property, you have two options. The one is to get divorced and remarried with an antenuptial contract in place, and the other is to apply to the High Court in terms of section, I think it's 25 of the Marriages Act. You apply to the High Court for them to grant what we call a postnuptial contract. which is basically the same thing, but it's post and not pre. Okay. In our country, because you would have been married in community of property, you would obviously have shared profit and loss with your spouse. So it's quite a lengthy and costly process in order for them to go through. In order for example, consent to be given by all the existing creditors that the parties may have, and that's just one example. But the post-nuptial contract is expensive and it takes time. And that's why for notaries to be able to do that, process and notarize the ANC and register it correctly in the deeds office initially is of so much importance, because fixing it down the line is, as I've mentioned, can be quite tricky.
Okay, thank you for that. Let me see. I have Liz. May I ask a FICA question? When listing, if the seller does not want to provide a proof of address or can't for some reason, may the agent do a declaration stating they have done a site visit? The sellers reside there, and when they get an offer, we get the valid proof of address like municipal account. Can they do that?
Okay. I think let's first just determine the difference between parties not wanting to provide proof of residence opposed to not being able to. Okay. There are very few instances where parties are not able to provide proof of residence. For example, if there's a lease agreement, we can utilize that. And as you know, municipal accounts, cell phone accounts, etc., etc. However, if they can't, then what we would do, and 100% correct, it would be sufficient enough to do a site visit and therefore a declaration as well, on behalf of that seller. If the parties just do not want to, that's a very different story, because it's required in terms of legislation that we collect, that when I say we, yourselves, us, the bond originators, the banks, we all are obligated in terms of the Act to collect the FICA. So should the client wish to proceed, they also need to abide by, those requirements.
Thank you for that. I think this one is for Dionalyn from Jackie. Some sellers don't declare they are married traditionally and state they are single. Transfer goes through only to find the wife or the husband in the house married customary. What happens next after the transfer has gone through, Dionalyn?
So sadly, we had a scenario very similar. And luckily, because we also have those affidavits where a person actually declares their marital status, we were able to utilize that as a proof in a court of law, because sadly this entire matter ended up in court now, as the party was now trying to, of course, defraud their partner by not sharing proceeds of sale. So sometimes it can go that route where it now ends up in court and the other party is seeking for damages from them hiding this funds. However, if it is in case where the person has not given us that information that they actually are married, they lied to you as the agent, and they've also now lied to us. So as long as the agent and ourselves have done the due diligence of getting that information in writing, then we will not be held liable for any of the consequences that will come with that.
Okay, thank you so much. Franklin says, it was just quickly touched upon in terms of the FFC. What happens if an agent with no FFC has sales? Can their commission ever be paid without their FFC? I think you're referring to what I was speaking about, to say we need to use property practitioners who have Fidelity Fund certificate when you're going to deal with conveyancers, so that if you don't have FFC, you cannot get your commission. And I gave an example where PPRA, they came across some practitioners when we received complaints who got commission. In fact, they were supposed to get commission, but they didn't have FFC. And I spoke about Delin Kambule. She collected some amounts. I'm not sure of the amounts. I think she will address that in our next webinar. She will give real practical examples of practitioners, who wanted to get commission, but they didn't have FFC. And I don't know if maybe Stacey would want to touch on that, to say if they work with practitioners, if they check for FFC. Maybe that's your question relating to that for Franklin.
Yeah, thanks, Naledi. Yeah, I think just to echo exactly what you've said, as much as you guys are required in terms of law to be in possession of an up-to-date FFC, we as the conveyancers are also required to have sight of that valid FFC prior to paying any commission out. And the ramifications for us alone, should we pay COM out without having that FFC in place, are also quite dire. So to answer your question, no FFC, no commission.
Thank you so much. And I think, Thapelo, it's the same question. So we've answered that. Let me go to Val. Let's see. So you will not require a foreign divorce decree authenticated. It looks like it's a follow-up because it starts with so. Do you understand the question, Stacey?
Yeah, I do. Val, so basically, if the parties own property already and they're registered already in this country, recorded in this country to be married by the laws of another country, and they then come to you and advise you that they are divorced or whatever the case may be, we would absolutely still need a copy of that proof of that divorce.
And Menzi, maybe to follow up on what Val is saying, he says, what is the difference between divorce decree and a settlement agreement for those who don't know?
Mm-hmm. Okay, that's also a great question. So a divorce decree is basically just a one-page document, and it's an order granted by the High Court confirming the parties and the date on which your divorce was made an order of court. Okay, so it's proof that the divorce has legally happened. The settlement agreement is the document where the parties record, where they deal, should I say, with anything related to them as a married couple. For example, custody of the children, sale of assets if relevant, etc., etc. There's all sorts of things that form part of that settlement agreement. That settlement agreement is also made an order of court, but that is an important document because that is the document that will tell us how the property needs to be dealt with. So in other words, have the parties agreed that they will sell the jointly owned property and split the proceeds, or will one party continue to live in that property and they will take transfer of the other spouse's share in that property? So it all just depends on what the parties agree upon.
Thank you. I'll take maybe another question from Emma and we take a 1-minute break. We play the last video, then we go back to the questions before we close at 12. I have Emma here, Stacey. If Jan had a property before he married Suzanne in community of property, then Suzanne passed away a year after the marriage, will the property fall into her estate? And will Jan be able to sell the property without an executor sign or on her estate behalf, without the executor signing on her estate?
Thank you so much for that question, Emma. So once again, when you're dealing with people that have been married in community or property, they're sharing assets. The fact that the person has unfortunately now died, it still means that the estate now has 50% owned.
You're breaking.
Have an executor who is dealing with that 50%. If it is the spouse, then the spouse can sign in their personal capacity and again as the executor of the estate.
Okay, thank you for that. Let me play another video that reflects the process of registrations under Snyman Inc. Okay, just give me a second.
To the final phase of your property journey with Snyman's Inc. It's time to celebrate as your property has now been registered and the transition of ownership becomes official. Following registration, it's essential to notify the municipality about the property transfer and ensure a smooth transition from the previous owner to the current owner. Rest assured, we'll provide you with all the necessary documents confirming the account's clearance and successful transfer of ownership. You might even be entitled to a refund from council, and we'll discuss this in detail during the signing of transfer documents. Exciting news for sellers. You receive the proceeds of your sale within approximately 72 hours of registration day. For buyers, any applicable refunds will be processed within approximately 72 hours of the registration date. Thank you for choosing Snyman's, where property transactions aren't just business, they're a journey with people at heart. We wish you all the best in your new property and may it be filled with happiness and cherished memories. Congratulations once again and goodbye from the Snyman's team.
Okay, thank you for that, your time, for staying with us up until now. I'm going to go back to the chat. I see we have another question coming from, let's see. Nosi says, proof of address, can a buyer use a bank statement for proof of address?
So yes, the buyer can use a bank statement. However, you will find that attorneys generally prefer something else that is not a bank statement. Reason being, especially when they're dealing with the purchasing process and they're getting a bond. Of course, then the bank will be utilizing that bank statement for purposes of finding them creditworthy. So we generally always ask for another more substantial form of proof of address, like a store account or anything else listed. The only thing that they do have, then it will be acceptable.
Thank you. Marike, what if your FFC is still registered under the previous company and you have been battling for months with the PPRA to get it transferred under the new company you are working for now? This one is for PPRA. I do know that if you can prove that PPRA was at fault, they will give you an affidavit that you can use to show that you were entitled to the FFC. But if the documents were non-compliant, they will also give you some reasons on that. But if you want maybe to engage on that, we have Advocate Vile in the registration. I can link you with her if you can drop me your email address and I'll connect you after the session. Let me see if I have another question. Okay, Sukaina, I have a property listing. The seller said she is divorced. Do I need proof from her for anything relating to the selling of the property, or can I just go ahead and sell the property based on what she gave me?
Thank you for the question. Yes, you will need to call for specific documents, the one being proof of the divorce decree, and the other one being the settlement agreement. It's very important that you have sight of that.
Okay, thank you for that. I'm gonna take a question from Liz. Do we report a seller when they do not want to be featured when listing? Okay, the question disappeared, colleagues. I don't know what happened to my chats. Let me go back. Okay, I found it. Apologies for that. Liz says, do we report a seller when they do not want to be featured when listing? Or must we just stop the listing because if we continue listing, we will not comply with FICA? I face a lot of difficulty here as a seller. Says we are the only ones requesting these documents, which poses a high concern. And while other agents still get to list, we can't list because we go with the law and we lose money.
So yeah, it is unfortunately very difficult trying to get FICA out of a client, but sadly it is again the law. So if a seller is refusing to provide such things, that should raise a lot of alarm bells to you as to exactly why they do not want to provide FICA to confirm that they are indeed the owner of this property. I would strongly suggest, sadly, that you do report them because, again, you do not want to be the only agent that is going to be found, of course, not complying. And we all understand the consequences of not complying with FIC.
I have a comment here from Mariki. Thank you for this very informative session. Hopefully, there will be many more. And yes, I think we can create a series out of this and see which other topics we can tackle, especially the issues that you have to go through when you're having to transact up until the property is registered with deed office. And let me see if I have another comment or question. Nomfundo, I think this is the last one, Stacy. Do we need a copy of the marriage certificate for FICA purposes, identification of the parties, or is this only to establish contractual capacity?
Yeah, that's actually a good question. So the anti-nuptial contract is not necessarily a FICA requirement, as it's not required to identify an individual or confirm identification of that individual. However, in order to confirm, as you mentioned, contractual capacity, yes, it's a requirement in order to get the marriage certificates or ANC.
Just to add on to Stacey's point that she just mentioned now, especially when you're dealing with couples or a couple that has a anti-nuptial contract, please do also ask for the marriage certificate. We do find in our office, we draft quite a number of anti-nuptial contracts, but it's not always that those people end up getting married. So again, an anti-nuptial contract is a contract between the parties, but you want to verify that they are actually married. So please ask for both.
Thank you for that. Let me see if I have another one. Matsididi says, I personally have that challenge, but I insisted and finally he agreed after sending the FICA form. Okay, this is a comment, maybe hearing the other question that were coming with FICA. Okay, the other ones regarding the FFC's colleagues, we did say in the beginning of the webinar to say when you put a query that's not related to today's webinar, put your email address so that I can send it to the relevant department so they can assist after the webinar and you can get your query resolved. They are available today in the offices. And if you are closer, please come to our offices and sit with a consultant so that they can assist. Let me see on the hands, we don't have anyone. I think we've answered all.
Naledi,
the
sorry, there's
questions.
one
Yes.
question that we've missed from Nomfundo, just regarding the FICA documentation required for a company, if the seller's a registered company.
Okay, so if you're dealing with a seller who is a company, of course, you're going to need all the SIPC documents. You also will need all of the directors' FICA. And again, this is where it can get slightly complicated in case you have any director who's married in community of property, etc., etc. So just make sure that you absolutely get all that FICA that you need. And then most importantly, you need a resolution. And in this resolution, it will do two things. It will nominate who is representing the company. And then also it is an acknowledgement that the company has decided to actually dispose of this asset. So it is to confirm that you can legally start selling and or list this property.
And just to add on,
Okay.
sorry, I'm not 100% sure if Dionan mentioned the MOI, which is the Memorandum of Incorporation, and that is your founding document for the company.
Okay, thank you. Ronel, I see your hand. Please unmute. Okay, let's go to Tapelo. Tapelo, please unmute. Okay, Tapelo's out. Let's go to Katlego. Katlego, please unmute. Ronel is still struggling. Katlego?
Afternoon, everyone. I just want to ask a very quick one to the statement that just gave or lastly here. What happens if a party who's married in community of property, but the property is underneath a company? Therefore, the partners of the company, one was only alone, the other one came along after the purchase of the property. In case when they divorce or there's death of the parties, the couple that was married in community of property, what happens then? But I guess you guys can hear where I'm going to. Thank you.
Okay, Katlego, I think I heard your question, but stop me if I misunderstood it. But basically, how I understand is the property is owned in the name of a company of which one of the directors is married in community of property. Is that correct?
Yes, that's correct.
And then, just tell me, then they
Therefore,
get divorced?
So when they get divorced or in case of the death of the couple that are married in community of property,
Yes.
when they purchase the property, one of the company partners only came along after the property has been purchased under the company.
Mhm.
What recourse would the partner who's married in community of property, what recourse would they have? Because what I'm thinking is that we can dispute that that other partner, because I presume companies, when you go 50-50, you will have the whatever assets or the company operation, whatever they have, you would also have those type of assets. So if it is an asset, but however your partnership, you signed that the appointments was after all these assets were accumulated, what happens then? May they be a divorce or even a death of that one partner?
Okay.
Okay, so if you recall, as part of the figure that you need when a company is selling, you do need a resolution. And in this resolution, all of the directors are confirming that they do indeed want to sell this asset. So that is part number one. Now, again, if all the directors are in agreement that they're selling this asset, you then need supporting figure documents to confirm that, again, they are all of them the directors of this company. Now, if you're having one of the director who happens to be married in community or property, you unfortunately will need their spouse's figure as well. Because remember, a person who's married in community of property cannot act alone. Now, should they get divorced after the fact, or they're now getting divorced, you would then still need to see a divorce decree to confirm that after the divorce has occurred, the ex-spouse does not have any rights to any of the shares of this property that you're dealing with. So it does get extensive in terms of the amount of figure that you have to collect. But unfortunately, please do collect it just to be on the safe side. You do not want to be found not compliant with any of those.
Okay, I have spoken. Let me see, there's a chart here. Mavis, divorce also requires winding up, right?
No. So when you're dealing with people that are getting divorced, I'm assuming what you mean when you say winding up, it is the division of assets that you find in the settlement agreement.
Okay.
But
let me see
winding
if
up
I
of the
missed.
estate is only for an estate late, not a divorce.
Okay, Nomfundo, can you please unmute? I'm trying to look for your question.
I already
Where you said
answered
I missed it.
Nomfundo's question, Naledi.
Oh, you managed to see it. Oh,
Yeah.
okay, because I'm looking, I couldn't find it. Thank you for that.
No
Tapelo
worries.
says, can I claim the commission due to an agent who doesn't have FFC? No, you can't. We've already answered that one. Let me see if there isn't a last question. I don't know why my chat keep on disappearing. Okay, I think we've answered all the questions so that we don't disadvantage anyone. Ronel, are you still struggling to unmute?
Yes, hi there. I'm sorry about that. I did mention in the comments as well. Can you hear me? Yeah. Okay. Just with regards to religious marriages, clients got married in South Africa, but the imam was flown in from abroad. How is that recognized? That's an interesting one, but it won't be recognized because the imam is not a marriage officer recognized by South African law. Yes, he's in Dubai, so I just wanted to make sure that I've got the right answer there. Thank you very much.
Yeah.
Very informative. Thank you. Pleasure.
Thank you. And for the colleagues asking a question, if we're getting CPD points, no, the session is for information just to empower you and for, knowledge. And I see we are done. The time is exactly 12 o'clock. I want to say thank you very much, Ms. Banat, Ms. Pongolani, for your information that you gave us today. The presentations were very comprehensive, very interesting, and we saw the questions that came out from that there's a need indeed for a second session, and we will continue to do that quarterly or monthly. We will see as we have other webinars lined up. We always try to get different speakers from private, public, intergovernmental to come and impart the knowledge that you might need, because as property practitioners, your work is connected with other bodies for you to facilitate your transaction up until the commission is released. It is a process. And we want to thank all the attendees for joining today's webinar. Your questions, your participation, your engagement, we appreciate that. And I think today what we can take away is that going forward, we know that we need to comply with the law. We need to be ethical when dealing with property transactions, especially when it comes to different marital regimes. And we know how to tackle them going forward. The speakers are going to share the slides. I will email everyone. I've seen your email addresses on the chat, and I have your email addresses to everyone who registered. Their contact details will be there. If you need a meeting with them, if you need a follow-up session, they are available. They will assist. The recording, please look out for it tomorrow on our YouTube channel. And we're going to have more webinars. Next week it's SARS, and we're still going to bring back daily because I feel like the topic she was going to speak on is important because it touches on offer to purchases and lease agreement breaches, termination clauses. I am still going to organize that for you, and we bring her to tackle that. So be on the lookout on our social media. We're going to post the link. I want to say to everyone who's in the meeting, you must stay safe today and enjoy the rest of your day. Stacey, Dionalyn, do you want to add before we close the meeting?
Just to once again thank you. It's been a pleasure chatting with you guys this morning. There's one last question from Jay. I think it's Jacqueline, if I'm not mistaken. Would you mind if I just quickly answered that?
Yes.
So what if the person purchased the property with a different boyfriend before she got married, and now she's married, selling that property? Do I need the husband's documents as well? So just remember that if her husband, who she's currently married to, if they're married in community of property, that husband will automatically own 25% of the property she owns with her previous boyfriend. So the answer is yes, if they are married in community of property. Thank you, Naledi. Thank you for a wonderful morning. And I will circulate that document to you for onward transmission.
That's an interesting question and answer, guys. Before you date, you buy. Just check, eh? Dionalyn? Any last word?
Oh, thank
Okay.
you all so much for having us. It was truly an enjoyable session, and we absolutely enjoyed how interactive it was as well. Thank you.
Okay. Thank you so much, colleagues. Goodbye. We'll see you next time.